Rule 11-504 is a physician-patient privilege in the state of New Mexico that we believe applies. And I, in my brief, cited the court to Bertrand and Roper, which are the two key cases for the exercise of that privilege. Our position is we have not waived this privilege in any way. We did not sign a waiver. It applies to the doctor. It applies to all hospital personnel. It applies to Artesia General Hospital. And later on, it applies to the hospital in Roswell where she was taken. The officers both say in their report that they told her she was detained, could not leave, and for purposes of Miranda, I would argue in custody and not free to leave, which means that at no time is there anything read about Miranda, which gets us to the suppression issue. The room, the doctor specifically states in the reports, and this is not in dispute because it's in the record. And of course, the police, she was in custody at the time that they went into the room. The doctor specifically states in the reports, and this is not in dispute because it's in the records and it's in the police reports. The doctor deliberately waits after they find the baby. The doctor deliberately waits until, and no other staff goes in until police officers arrive, and they all go in at one time. And that's where we get into the Miranda issues. So for the privilege, I'm saying everything's privileged up to the time she goes into the bathroom. Everything's privileged after she comes out, because it's all part of the privilege.
Okay, now let me stop you here because I want to clarify. I'm looking at Rule 504. We have the doctor-patient privilege. This is an exception to the other rules. Who has the obligation? Does the doctor, and is this in case law? I'm not seeing it here in the privilege. It says who may claim the privilege. Is the doctor obligated under this act or anything else to invoke it, or at least advise the patient of their privilege, or invoke it on behalf of their patient? What is their obligation?
The doctor and the hospital's obligation is, until they have a proper waiver of that privilege, they can't talk about it. And here's,
okay. And then she has to make a knowing waiver after being advised what her right is in event to waive it.
Well,
right?
There's no case law on what a knowing waiver is. That's always been, did she sign a waiver? Okay. We've always done that on a case-by-case basis. I'm not going to tell you that I have a particular case, although I haven't done this in civil cases, and in other cases, classically, there's a written waiver that is signed that you can waive that. And that's not done in this case. And my client is not a child. She was 19 at the time. They had the waiver from her. They never got it. And here's the problem for all of us in this case. Okay. There's a huge problem. Is mass media, social media, how it got out is, I guess, an issue that the district attorney and I will have to look to sooner or later. But the truth is, it got out. All these records, all these videos were out. Now, somebody from Artesia had to disclose that. Every one of them gave a statement to police. They shouldn't have without a waiver. They all gave records they shouldn't have without a waiver. They gave a video they shouldn't have without a waiver. And classically, when you read the case law, there are three ways. Number one, you get a waiver from the patient. Number two, a court orders it. There is no court orders in this case. They didn't go down and say, Judge, we need a search warrant. We need an order from you ordering the hospital to turn over the stuff to us. They never did that. They just did it. And then, in fact, there's a videotape in this case where the officer goes in and asks the administrator of the hospital, what do I need to do? He says, well, just send me an email. That doesn't cut it. It doesn't cut it under HIPAA. It doesn't cut it under this rule. So my point is that the privilege applies. Now, I could choose to waive part of that as her attorney, or she could waive part of it. We haven't chosen to waive any of this. And as a matter of fact, the state knows this. At the very beginning of the preliminary hearing in this case and the motion, what I did was
Mr. Mitchell, I was muted, you're muted. Something happened. I don't know what. Can you can you repeat everything you just said? I am sorry. It just my screen muted you.
I don't know how long I was muted for, but here.
Let's go back about 60 seconds, I think.
Well,
I'm sorry.
Here's the point, Judge. I've never waived this on behalf of my client. My client's never waived it. At the preliminary hearing in this matter and the motion to set conditions of release, I objected right before we ever got started receiving evidence to the court, exercising the privilege, alerting the court to the issue, alerting the court to HIPAA, alerting the court to the doctor-patient privilege, and my belief that it covered Artesia General Hospital in this case. Mm-hmm. And he gave me a continuing objection throughout the entire hearing, and I've never waived it since then, and I've never waived it before this court. So that's what we think is covered by the privilege. So all these medical records, all of these statements by doctors and nurses that were taken without waiver, all of the lab reports, not the state lab reports, not those that come on the examination of the baby, but those that were examination of my client, that would be the blood test results, pregnancy test results, things of that particular nature. All of that is privileged. Everything there is privileged and should never have been disclosed. And we need a determination from the court that it's privileged. And if the court decides it's privileged, then unless I waive it, or there's another, and I don't know of any other reason, because the privilege is a privilege, under Roper and then Bertrand and the rule, that remains privilege and cannot be used in court. So that's the argument on the privilege, and I'll submit it to the court in that regard, and then we can argue the suppression issue later.
Okay. All right. Thank you. And I'm looking at the act. Privilege is that to be claimed by the patient or their guardian or custodian, which doesn't apply. It's a personal right by the patient. And it says who may assert the privilege on their behalf would be their physician or whoever treats them. Authority to claim the privilege is presumed, absent evidence to the contrary. Exceptions, well, it says by order of the court. Okay, so I understand what I'm looking at. Exceptions, well, it says by order of the court. Okay, so I understand what I'm looking at. Let me hear your side of this argument, Ms. Luce.
Your Honor, basically defense in their motion raised three issues. They raised the issue of Miranda, they raised the issue of HIPAA, and they raised the issue of privilege by the rule. Mm-hmm. Let me start with the issue of Miranda. Okay. The issue of Miranda, she was not in custody. Statements that she made once the police were there were actually statements initially that she blurted out. Officers asked her no questions. And then her mother, who is present with her in the treating room the entire time, is saying things to her. And the officers actually tell the mother to stop, that she, has Miranda rights and that she should be advised. And so we think the Miranda issue is really not an issue. There's not a violation of Miranda. And we put that in our response. The second thing is HIPAA. The defense puts HIPAA in here. HIPAA is really a red herring. Has nothing to do with the criminal case. There's no remedy. It's not a constitutional protection. It's a statutory protection in which a penalty can be against the facility, the physician, and that is the civil suit that two civil suits, I believe, that defense counsel has already.
Yeah, and I think Mr. Mitchell doesn't disagree with you on that point.
Right. Well, no, but he put it in his motion, Your Honor, and so
okay.
For the purposes of the record, the state's just making an argument.
He acknowledged to me that the HIPAA is it's a federal issue. It's a remedy that doesn't even run to the patient, apparently.
Right.
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 I understand. Okay.
So it really had no place in his motion, but it was there. So the third is the rule. And so let's start with defense has kind of combined a lot of things together. statements made by treating personnel, doctors, nurses, records, video. He's kind of lumped all that together. The state doesn't believe that's proper. First of all, the defendant's mother, this defendant is an adult, the defendant's mother was present at all times. You can't have privilege if a third party is present in the room. And so.
You just went mute again. I'm having trouble with this. I think it's our system. Okay, go ahead. It's about 10 seconds. Okay, go ahead, I think.
The defendant's mother is present in the room with her at the emergency room. She's not with her in the restroom, but she's with her when the nurses, doctors, anyone is speaking with her. You can't have a privilege if you have a third party present. You've already, by your own actions, letting your own mother be there, waived that privilege. So statements that are made are not going to be protected under this rule. She's an adult. If she was a minor, that would be different. So statements, that's one thing.
You're muted again.
Records, the hospital records, the police department was given the records, but they did apply for a search warrant and obtain records properly by court order. And so a claim of privilege that we didn't get them by court order for a crime, the state believes that that is the exception. And allows us to use those tests from the lab as well as the records. The third thing is apparently the claim of the security video for the hospital for the hallway. The state would submit.
You're muted again. Okay, go ahead.
Yeah, Your Honor, it's showing that there's somebody on as a participant that is muting people, just so that the court knows.
Okay, that's good to know. If anybody's trying to mute, please stop messing with the system, all right? You can mute yourselves, but please don't mute my litigants here. All right, go ahead.
So, Your Honor, the video in the hallway, defense is arguing that that video is privileged. The hallway would be a public corridor within the hospital. It's not a private patient room. It wasn't the restroom. The fact that other people can access that hallway and be in that hallway, we don't believe that there's any right of patient physician confidentiality for a public hallway. It wouldn't be any different than when the court has a closed proceeding in the courtroom. Whatever's going on in the hallway of the courthouse is not a protected, secluded area. And so for them to try to argue that because it shows a bathroom in the hallway where she comes in and out of, that doesn't make it patient protected privilege. So I think really you have to separate out the three.
Again, go ahead.
The three types of evidence involved, from statements that are made where her mother is in the room and then later the police are in the room. It's definitely argument for defense counsel to say that the doctors deliberately, intentionally waited for the police to go in. I think that's probably at this point an assumption on behalf of defense counsel because we've had no doctor testimony to say that. But either way, the fact that the mother was already in the room, there's no right of privilege. There's no claim of privilege that's been waived. She came with her mother. She allowed her mother to be present. The court would be familiar that a patient has a right to not have other people in their room. They ask if it's okay if that person stays. That's normal treatment. The state would submit. So, Your Honor, we believe there are three different things going on here. And for defense to lump it all in and say it's all privilege before the court, we would disagree.
I'm sorry. We discovered a dead baby in the bathroom. Oh my gosh. I'm sorry. He came out and I didn't know what to do. Lexi, I told you about this. I just asked you, baby, to tell me the truth. Scared. It was not crying or nothing.
What did you do to it?
Okay, stop right here.
Stop.
Number one priority, guys. Number one priority is she just had a baby. I don't know if she's delivered the placenta. She's bleeding significantly.
Yeah.
I've spoken to the obstetrician at Loveless. They want her up there as soon as possible.
Okay.
I need your permission to transfer her for medicals. She's
19.
Oh, you're right.
But she is a student too.
She's
No,
still
no,
19
you're
years old.
right. You're right. She needs to. I'm sorry, I forgot she's 19.
Keep out of me.
I got to tell you, both counsel, and I really do appreciate you're both rational, competent, really good attorneys, and I really enjoy having you in my court. And you save this court a whole lot of headache. I appreciate that. That's duly noted.
All right. That's all I had for today.
Okay.
Lick my balls like you're
Hey, somebody. Isabel is having a little hissy fit here on our sound system, I guess. I don't know who Isabel is.